In this installment of Washington Legal Foundation's Legally Brief, Gibson Dunn Crutcher partner David Debold, who serves as co-chair of the United States Sentencing Commission's Practitioners Advisory Group, will discuss the sentencing guidelines and how their application affects corporate criminal enforcement.
In 1984, Congress passed legislation to reform sentencing for federal crimes. There were two main objectives. First, truth in sentencing. That was rather easy to implement. With a few strokes of the legislative pen, parole was abolished and early release for good behavior was curtailed. From then on, the sentence imposed, by and large, would be the sentence served. The second objective, a reduction in what was viewed as unjustifiably disparate sentences for defendants with similar culpability, has proved much more elusive. In fact, it is widely believed that the pursuit has exacted too high a price in the form of rigid uniformity that has stifled the discretion of judges to tailor each sentence to the unique circumstances of each case. Because of the inherent tension between individualized sentencing and uniformity, a certain price, a trade-off of those competing interests, was inevitable. But when Congress delegated to a newly formed sentencing commission the task of drafting a system of sentencing guidelines, that agency then proceeded to add a third, unscripted, and unnecessary dimension to sentencing reform: substantial increases in the penalties imposed for numerous federal offenses. The side effect of this decision to transfer sentencing policymaking from the legislature and the courts to an unelected administrative agency is particularly noticeable in the area of nonviolent white-collar offenses. From fraud crimes to tax offenses to environmental violations, the result has been a marked increase in the length of sentences served, as well as a substantial decrease in the discretion of judges to impose sentences that contain appropriate alternatives to imprisonment. These results stand in stark contrast to Congress's general directive that guideline sentences should reflect the average sentence served in the pre-guidelines era, and they are nearly impossible to reconcile with Congress's more specific directive that probation should be available for first-time offenders convicted of nonviolent and otherwise non-serious offenses. This problem was aggravated by the fallout from the Enron scandal. In 2002, just after the Commission had completed a multi-year project to revise the guidelines for economic crimes, including higher sentences for most serious fraud offenses, Congress passed the Sarbanes-Oxley Act. It required the Commission to amend the recently amended guidelines, and the Commission responded with a number of new cumulative and overlapping sentence enhancements that led to the doubling and even tripling of sentence ranges. For example, corporate executives convicted of offenses that result in a relatively small percentage drop in the value of a publicly traded stock can now easily face sentences of 30 or more years. This kind of result, even in the extreme fraud case, was unheard of in the pre-guidelines era. Now it is all too frequent. The same transformation has occurred with environmental crimes. Pre-guideline sentences for such offenses were fairly uniform and rarely involved incarceration. Now prison terms are quite frequent, yet the Commission has not explained, much less justified, its sharp departure from prior practices. Penalties for corporate defendants have likewise rocketed upward. Between 1995 and 2001, for example, the average organizational fine increased almost tenfold and the median fine doubled. In another 4 years, the average fine had doubled yet again. These substantial increases in punishment, especially over a relatively short period of time, create distortions in the system. Defendants face incredible pressure to plead guilty and thereby limit their sentence exposure. Winning acquittals, or on most or nearly all charges, can turn out to be a very hollow victory. Under the guidelines, acquitted conduct is routinely counted the same as conduct that resulted in a guilty verdict. A defendant who chooses to plead guilty early and provide testimony against others can receive a substantial sentence reduction. Although the results of sentencing reform have been discouraging, there is a glimmer of hope. Over the past 4 years, the Supreme Court has enforced the Sixth Amendment right to a jury trial by converting the guidelines to advisory rather than mandatory status. Judges are now directed to treat a recommended guideline range as one factor among many in determining whether a sentence is sufficient but not greater than necessary to achieve the purposes of sentencing. Trial and appellate courts have been slow to adapt to this significant change in the status of the guidelines. but with vigorous advocacy by defense counsel, drawing attention to factors that justify a sentence below the guidelines, along with a willingness by the courts to restore rationality to the sentencing of these nonviolent offenses, a swing of the pendulum back in the direction of punishment that matches both the offense and the offender is possible.
To learn more about the sentencing guidelines and how they affect business civil liberties, we encourage you to go to our website, www.wlf.org, and download the special report, Federal Erosion of Business Civil Liberties, a report the Washington Legal Foundation has compiled, which includes a chapter on sentencing guidelines, which is Chapter 7.